Hey, everybody. All right. Good evening, everybody. We're doing the Remedies reading for tonight. We are talking about what's called structural injunctions or institutional reform litigations. We only have one case tonight, but it's a long case. It's a 2011 Supreme Court case called Brown versus Plata. Justice Kennedy, the Romantic poet, delivered the opinion of the court. He said, "This case arises out of serious constitutional violations in California's prison system. These violations have persisted for years, and they remain uncorrected. After years of litigation, it became apparent that a remedy for the constitutional violations would not be effective absent a reduction in the prison system population. The authority to order release of prisoners as a remedy to cure a systematic violation of the Eighth Amendment is a power reserved to a three-judge district court, not a single-judge district court. Appeals from a three-judge district court go directly to the Supreme Court. The appeal presents the question whether the remedial order issued by the three-judge court is consistent with the requirements and procedures set forth in the Prison Litigation Reform Act of 1995, hereafter the PLRA. Part 1, A. The degree of overcrowding in California's prisons is exceptional. California's prisons are designed to house a population just under 80,000. But at the time of the three-judge court's decision, the population was about 156,000. The state's prisons had operated around 200% of design capacity for at least 11 years. Prisoners are crammed into spaces neither designed nor intended to house inmates. As many as 200 prisoners may live in a gymnasium, monitored by as few as 2 or 3 correctional officers. As many as 54 prisoners may share a single toilet. Prisoners in California with serious mental illnesses do not receive minimal, adequate care. Because of a shortage of treatment beds, suicidal inmates may be held for prolonged periods in telephone booth-sized cages without toilets. A psychiatric expert reported observing an inmate who had been held in such a cage for nearly 24 hours, standing in a pool of his own urine, unresponsive and nearly catatonic. Prison officials explained that they had no place to put him. Other inmates awaiting care may be held for months in administrative segregation, where they endure harsh and isolated conditions and receive only limited mental health services. Wait times for mental health care range as high as 12 months. In 2006, the suicide rate in California's prisons was nearly 80% higher than the national average for prison populations, and a court-appointed special master found that 72.1% of suicides involved, quote, some measure of inadequate assessment, treatment, or intervention, and were therefore more probably foreseeable and or preventable. Prisoners suffering from physical illness also receive severely deficient care. California's prisons were designed to meet the medical needs of a population at 100% of design capacity, and so have only half the clinical space needed to treat the current population. A correctional officer testified that in one prison, up to 56 inmates may be held together in a 12 by 20-foot cage for up to 5 hours awaiting treatment. The number of staff is inadequate, and prisoners face significant delays in access to care. A prisoner with severe abdominal pain died after a 5-week delay in referral to a specialist. A prisoner with constant and extreme chest pain died after an 8-hour delay in evaluation by a doctor. A prisoner died of testicular cancer after a failure of the medical doctors to work up for cancer in a young man with 17 months of testicular pain. Dr. Ron Shansky, former medical director of the Illinois State Prison System, surveyed death reviews for California prisoners. He concluded that extreme departures from the standard of care were widespread and that the portion of possibly preventable or preventable entirely deaths was extremely high. B. These conditions are the subject of 2 federal cases. The first to commence, Coleman v. Brown, was filed in 1990. Coleman involves the class of seriously mentally ill persons in California prisons. After a 39-day trial, the Coleman District Court found, quote, overwhelming evidence of the systematic failure to deliver necessary care to mentally ill inmates in California prisons. Coleman v. Wilson, which is a 1995 case, the court appointed special master to oversee development and implementation of a remedial plan of action. In 2007, 12 years after his appointment, Special Master in Coleman filed a report stating that after years of slow improvement, the state of mental health care in California's prisons was deteriorating. The special master ascribed this change to increased overcrowding. Existing programmatic space for staffing levels was inadequate to keep pace. The need to house the expanding population had also caused a reduction of programming space now occupied by inmate bunks. The special master concluded that many early achievements have now succumbed to the inexorably rising tide of population, leaving behind growing frustration and despair. Not great. The second action, Plata v. Brown, involves a class of state prisoners with serious medical conditions. After this action commenced in 2001, the state conceded that its deficiencies in prison medical care violated prisoners' Eighth Amendment rights. The state stipulated to a remedial injunction. The state failed to comply with that injunction, and in 2005, the court appointed a receiver to oversee remedial efforts. The court found that, quote, the California prison medical care system is broken beyond repair, resulting in, quote, unconscionable degree of suffering and death. The court found, quote, it is uncontested fact that on average, an inmate in one of California's prisons needlessly dies every 6 to 7 days due to constitutional deficiencies in California prison's medical delivery system. Prisons were unable to retain sufficient numbers of competent medical staff and would, quote, hire any doctor who had a license, a pulse, and a pair of shoes, end quote. Medical facilities lacked, quote, necessary medical equipment and did not, quote, have neat medical basic sanitation standards. And, quote, exam tables and countertops where prisoners with communicable diseases are treated were not routinely disinfected. In 2008, 3 years after the district court's decision, the receiver described continuing deficiencies in the health care provided to California prisoners. There's a typo in this book. Continuing deficiencies in the health care provided by The receiver explained that, quote, overcrowding combined with staffing shortages has created a culture of cynicism, fear, and despair, which makes hiring and retaining competent physicians extremely difficult. Quote, overcrowding and the resulting day-to-day operational chaos of the prison system creates regular crisis situations which take time and energy away from important remedial programs, end quote. Overcrowding had increased in the incidence of infectious disease and had led to rising prison violence and greater reliance by custodial staff on lockdowns, which inhibit the delivery of medical care and increase the staffing necessary for any care being delivered. Part D. The three-judge court heard 14 days of testimony and issued a 184-page opinion, making extensive findings of fact. The court ordered California to reduce its prison population to 137.5% of the prison's design capacity within 2 years. Assuming the state does not increase capacity through new construction, the order requires a population reduction from 38,000 to 46,000 persons. Because it appears all but certain that the state cannot complete sufficient construction to comply fully with the order, the prison population will have to be reduced to at least some extent. The court did not order the state to achieve this reduction in any particular manner. Instead, the court ordered the state to formulate a plan for compliance and submit its plan for approval by the court. Part 2. As a consequence of their own actions, prisoners may be deprived of rights that are fundamental to liberty, yet the law and the Constitution demand recognition of certain other rights. Just as a prisoner may starve if not fed, or he or she may suffer or die if not provided adequate medical care. A prison that deprives persons of basic sustenance, including adequate medical care, is incompatible with the concept of human dignity and has no place in civilized society. If the government fails to fulfill its obligation, the courts have a responsibility to remedy the resulting Eighth Amendment violation. Courts must be sensitive to the state's interest in punishment, deterrence, and rehabilitation, as well as a need for deterrence to experienced and expert prison administrators faced with the difficult and dangerous task of housing large numbers of convicted criminals. But courts may not allow constitutional violations to continue simply because a remedy would involve instruction to the realm of prison administration. Courts faced with a sensitive task of remedying unconstitutional prison conditions must consider a range of available options, including appointment of special masters or receivers. When necessary to ensure compliance with the constitutional mandates, courts might enter orders placing limits on prison population. Before a three-judge court may be convened to consider such an order, a district court first must have entered an order for less intrusive relief that failed to remedy the constitutional violation and must have given the defendant a reasonable time to comply with the prior orders. The three-judge court must then find by clear and convincing evidence that, quote, crowding is the primary cause of the violation of a federal right, close quote, and that, open quote, no other relief will remedy the violation of the federal right, close quote. As with any award of prospective relief under the PLRA, the relief, quote, shall extend no further than necessary to correct the violation of the federal right in a particular plaintiff or plaintiffs. That's U.S. Code Section 3626A1A. The three-judge court must therefore find that the relief is narrowly drawn and extends no further than necessary and is the least intrusive means necessary to correct the violation of a federal right. In making the determination, the three-judge court must give, quote, substantial weight to any adverse impact on public safety or the operation of the criminal justice system that would be caused by the relief itself. Applying these standards, the three-judge court found a population limit appropriate, necessary, and authorized in this case. This court's review of the three-judge court's legal determinations is de novo, but factual findings are reviewed for clear error. 2A. The court contends that there was error to convene the three-judge court without affording it more time to comply with the orders prior to Coleman and Plata. 2. When the three-judge court was convened, 12 years had passed since the appointment of the Coleman special master and 5 had passed from the approval of the Plata consent decree. The state does not claim that either of the orders achieved a remedy. The state claims instead that other later remedial efforts should have been given more time to succeed. There were new orders or proposals for construction of new facilities, hiring new staff, implementation of new procedures, in each case in 2006 or later. The failed consent decree in Plata had called for new procedures and additional staff, and the Coleman special master had issued over 70 orders directed at achieving a remedy through construction, hiring, and procedural reforms. Having engaged in remedial efforts for 5 years in Plata and 12 in Coleman, the district courts were not required to wait to see whether their more recent efforts would yield equal disappointment. When a court attempts to remedy an entrenched constitutional violation through reform of a complex institution, it may be necessary in the ordinary course to issue multiple orders directing and adjusting ongoing remedial efforts. Each new order must be given a reasonable time to succeed, but reasonableness not be assessed in the light of the entire history of the court's remedial efforts. The Coleman and Plata courts had a solid basis to doubt that any additional efforts to build new facilities or hire new staff would achieve a remedy. A report filed by the Coleman Special Master in July of 2009 describes ongoing violations, including a, quote, absence of timely access to appropriate levels of care at every point in the system, close quote. A report filed by the Plata receiver on October 2010 likewise describes the ongoing deficiencies in the provision of medical care and concludes that there are simply too many prisoners for the healthcare infrastructure. The Coleman and Plata courts acted reasonably when they convened a three-judge court without any further delay. B. Once a three-judge court has been convened, the court must find additional requirements satisfied before it may impose a population limit. The first of these requirements is that, quote, crowding is the primary cause for the violation of a federal right, close quote. The three-judge court found the primary cause requirement satisfied by evidence at trial. The court found the overcrowding strains inadequate medical and mental health facilities, overburdens limited and clinical custodial staff, and creates violent, unsanitary, and chaotic conditions that contribute to the constitutional violations and frustrate any effort to fashion a remedy. The three-judge court also found that, quote, until the problem of overcrowding is overcome, it will be impossible to provide constitutionally compliant care to California's prison population, close quote. The record documents the severe impact of burgeoning demand on the provision of care. At the time of trial, vacancy rates for medical and mental health staff ranged as high as 20% for surgeons and 25% for physicians, 39% for nurse practitioners, and 51.4% for psychiatrists. These percentages are based on the number of positions budgeted by the state. Dr. Shansky concluded that these numbers understate the severity of the crisis because the state has not budgeted sufficient staff to even meet the demand it has. On the assumption that vacant positions could be filled, the evidence suggests there would still be insufficient space for the necessary additional staff to perform their jobs. Staff operate out of converted storage rooms, closets, bathrooms, shower rooms, and visiting centers. These makeshift facilities impede the effective delivery of care and place the safety of medical professionals in jeopardy, compounding the difficulty of hiring additional staff. The shortfall of resources relative to demand contributes to significant delays in the access to treatment. Prisons have backlogs of up to 700 prisoners waiting to see a doctor. A review of referrals for urgent specialty care at one prison revealed that only 105 of 316 pending referrals had a scheduled appointment, and only 2 had an appointment scheduled to occur within 14 days. Urgent specialty referrals at one prison had been pending for 6 months to a year. Crowding also creates unsafe and unsanitary living conditions that hamper effective delivery of medical care and mental health care. Cramped conditions promote unrest and violence. Increased violence requires increased reliance on lockdowns to keep order. The lockdowns further impede the effective delivery of care. In 2006, prison officials instituted 449 lockdowns. The average lockdown lasted 12 days, and 20 lockdowns lasted 60 days or longer. During lockdown, staff must either escort prisoners to medical facilities or bring medical staff to the prisoners. Either procedure puts additional strain on already overburdened medical and custodial staff. Some programming for the mentally ill even may be canceled altogether during lockdowns, and staff may be unable to supervise the delivery of psychotropic medications. The effects of overcrowding are particularly acute in prisons' reception centers, intake areas that process 140,000 new or returning prisoners every year. Crowding in these areas runs as high as 300% of design capacity, and inmates spend long periods of time in these areas awaiting transfer to the general population. Some prisoners are held in the reception centers for their entire period of incarceration. Numerous experts testified that crowding is the primary cause of the constitutional violations. The court quoted testimony by the former warden of San Quentin and 3 current or former heads of prison systems in other large states. 2. The state's complaint that the 3-judge court excluded evidence of current conditions in the prisons lacks a factual basis. The state does not point to any significant evidence that it was unable to present, and it would have changed the outcome of the proceedings. 3. The 3-judge court acknowledged that the violations were caused by factors in addition to overcrowding, and that reducing crowding in the prisons would not entirely cure the violations. Even significant reduction in prison population would not remedy the violations absent continued efforts to train staff, improve facilities, and reform procedures. The 3-judge court nevertheless found that overcrowding was the primary cause in the sense of being the foremost cause of these violations. Overcrowding need only be the foremost chief or principal cause of the violation. If Congress had intended to require that crowding be the only cause, it would have said so. As this case illustrates, constitutional violations in conditions of confinement are rarely susceptible of simple or straightforward solutions. In addition to overcrowding, the failure of California's prisons to provide adequate medical care and mental health care may be ascribed to chronic or worsening budget shortfalls, a lack of political will in favor of reform, inadequate facilities, and systematic administrative failures. Only a multifaceted approach aimed at many causes, including overcrowding, will yield a solution. A reading of the PLRA that would render population limits unavailable in practice would raise serious constitutional concerns. A finding that overcrowding is the, quote, principal or primary cause, end quote, of a violation is therefore permissible, despite the fact that there are additional causes and additional steps required to remedy the violation. C. The 3-court judge was also required to find by clear and convincing evidence that no other relief will remedy the violation of the prisoner's federal rights. Section U.S. Code 3626A3E2. The state argues that the violation could have been remedied through a combination of new construction, transfers of prisoners out of state, hiring of medical personnel, and continued efforts by the Plata receiver and Coleman special master. The order, in fact, permits the state to comply with a population limit by transferring prisoners to county facilities or facilities in other states, or by constructing new facilities to raise the prison's design capacity. If the state does find an adequate remedy other than a population limit, it may seek modification or termination of the 3-judge court's order on that basis. Aside from asserting that these remedies could still work, the state offers no reason to believe it is so. The common thread connecting the state's proposed remedial efforts is that they would require the state to expend large amounts of money absent a reduction in overcrowding. The court cannot ignore the political and fiscal reality behind the case. California's legislature has not been willing or able to allocate the resources necessary to meet this crisis absent a reduction in overcrowding. There is no reason to believe it will begin to do so now, when the state of California is facing unprecedented budgetary shortfall. The PLRA states that no prospective relief shall issue with respect to prison conditions unless it is narrowly drawn, extends no further than necessary to correct the violation of a federal right, and is the least intrusive means necessary to correct the violation. When determining whether these requirements are met, courts must give substantial weight to any adverse impact on public safety or the operation of a criminal justice system. 1. The three-judge court acknowledged that its order, quote, is likely to affect inmates without medical conditions or serious mental illness, close quote. This is because reducing California's prison population will require reducing the number of prisoners outside the class through steps such as parole reform, sentencing reform, use of good time credits, or other means determined by the state. Reducing overcrowding will also have positive effects beyond facilitating timely and adequate access to medical care, including reduction of the incidence of prison violence and ameliorating unsafe living conditions. According to the state, these collateral consequences are evidence that the order sweeps more broadly than necessary. The population limit imposed by the three-judge court does not fail narrow tailoring simply because it will have positive effects beyond the plaintiff's class. Narrow tailoring requires, quote, a fit between the remedy's ends and the means chosen to accomplish those ends. That's from Board of Trustees versus Fox, an '89 Supreme Court case. The scope of the remedy must be proportional to the scope of the violation, and the order must extend no further than necessary to remedy the violation. This court has rejected remedial orders that unnecessarily reach out or to improve prison conditions other than those that violate the Constitution. But the precedents do not suggest that a narrower or otherwise proper remedy for a constitutional violation is invalid simply because it will have collateral positive effects. Nor does anything in the text of the PLRA require that result. The PLRA states that a remedy shall extend no further than necessary to remedy the violation of rights of, quote, a particular plaintiff or plaintiffs, close quote. This means only the scope of the order must be determined with reference to constitutional violations established by the specific plaintiffs before the court. This case is unlike cases where courts have impermissibly reached out to control the treatment of prisoners or institutions beyond the scope of the institution's violation. See Dayton, a case called Dayton. Even prisoners with no present physical or mental illness may become afflicted, and all prisoners in California are at risk so long as the state continues to provide inadequate care. Prisoners in the general population will become sick and will become members of the plaintiff class, who with routine frequency, and overcrowding may prevent the timely diagnosis and care necessary to provide effective treatment to further prevent the spread of disease. Relief targeted only at prison members of the plaintiff's class may therefore fail to adequately protect future class members who will develop serious physical or mental illnesses. Prisoners who are not sick or mentally ill do not yet have a claim that they have been subjected to care that violates the Eighth Amendment, but in no sense are they remote bystanders in California's medical care system. They are that system's next potential victims. A release order limited to prisoners within the plaintiff's classes would, if anything, unduly limit the ability of the state officials to determine which prisoners should be released. As the state acknowledges in its brief, quote, release of seriously mentally ill inmates would likely to create special dangers because of their recidivism rate, end quote. In reaching its decision, the three-judge court gave, quote, substantial weight to any potential adverse impact on public safety from its order. The court devoted nearly 10 days of trial to the issue of public safety and gave it the question of extensive attention in its opinion. Ultimately, the court concluded that it would be possible to reduce the prison population, quote, in a manner that preserves public safety and the operation of the criminal justice system. The PLRA's requirement that a court give, quote, substantial weight to public safety does not require the court to certify that its order will have no possible adverse impact on the public whatsoever. A contrary reading would depart from the statute's text by replacing the word substantial with the word conclusive. A court is required to consider the public safety consequences of its order and to structure and monitor its ruling in a way that mitigates those consequences while still achieving an effective remedy for these constitutional violations. This inquiry necessarily involves difficult, predictive judgments regarding the likely effect of the court orders. Although these judgments are normally made by state officials, they necessarily must be made by courts when these courts fashion injunctive relief to remedy serious constitutional violations in the prisons. These questions are difficult and sensitive, but they are factual questions and should be treated as such. Courts can and should rely on relevant and informed expert testimony when making factual findings. The three-judge court credited substantial evidence that prison populations can be reduced in a manner that does not increase crime to a significant degree. Some evidence indicated that reducing overcrowding in California prisons could even improve public safety by reducing the extent to which the prison system made criminals worse than when they entered it.
Expert witnesses produced statistical evidence that prison populations had been lowered without adversely affecting public safety in a number of jurisdictions, including certain counties in California, as well as Wisconsin, Illinois, Texas, Colorado, Montana, Michigan, Florida, and Canada, who's not a state, but fair enough. The court found that various available methods of reducing overcrowding would have little or no impact on public safety. Expansion of good time credits would also or would allow the state to give early release to only those prisoners who pose the least risk of reoffending. Diverting low-risk offenders to community programs such as drug treatment, day reporting centers, or electronic monitoring would likewise lower the prison population without releasing violent criminals. The state now sends large numbers of persons to prison for violating a technical term or condition of their parole, and it could reduce the prison population by punishing technical parole violations through community-based work programs. 3. Establishing the population at which the state should begin to provide constitutionally adequate medical and mental health care and the appropriate time frame within which to achieve the necessary reduction requires a degree of judgment. The inquiry involves uncertain predictions regarding the effects of the population reductions, as well as difficult determinations regarding the capacity of prison officials to provide adequate care at various population levels. Courts have substantial flexibility making these judgments. Once invoked, the scope of a district court's equitable powers is broad, for breadth and flexibility are inherent in equitable remedies. Hutto v. Finley, a U.S. Supreme Court decision from 1978, quoted Milliken II and Swan decisions, saying, nevertheless, the PLRA requires a court to adopt a remedy that is, quote, narrowly tailored to the constitutional violations and that gives substantial weight to public safety. When a court is imposing a population limit, this means the court must set the limit at the highest population consistent with an efficacious remedy. The court must also order the population reduction achieved in the shortest period of time, reasonably consistent with public safety. All right. A. The three-judge court concluded that the population of California's prisons should be capped at 137.5% of design capacity. This conclusion is supported by the record. Indeed, some evidence supports a limit as low as 100% of divine capacity. Other evidence supports a limit as low as 130%. Although the three-judge court concluded that evidence in support of the 130 limit is strong, it found some upward adjustment was warranted in light of the caution and restraint required by PLRA. The three-judge court imposed a limit of 137.5%. This weighing of the evidence was not clearly erroneous. The plaintiff's evidence showing was clear. The plaintiff's evidentiary showing was intended to justify a limit of 130%, and the state made no attempts to show that any other number would allow for a remedy. The three-judge court made the most precise determination it could in light of the record before it. The PLRA's narrow tailing requirement is satisfied so long as these equitable remedial judgments are made with the objective of releasing the fewest possible prisoners consistent with an efficacious remedy. In light of the substantial evidence supporting an even more drastic remedy, the three-judge court complied with the requirements of the PLRA in this case. B. The three-judge court ordered the state to achieve this reduction within 2 years. The state first had noticed that it would be required to reduce its prison population in February of 2009, when the three-judge court gave notice of its tentative ruling after trial. The 2-year deadline, however, will not begin until this court issues its judgment. When that happens, the state will already have had over 2 years to begin complying with the court order from the three-judge court. The state has used this time productively. At oral argument, the state indicated it had reduced its prison population by approximately 9,000 persons after the decision of the three-judge court. After oral argument, the state filed a supplemental brief indicating it had begun to implement measures to shift thousands of additional prisoners to county facilities. The three-judge court, however, retains the authority and the responsibility to make further amendments to the existing order or any modified decree it may enter as warranted by the exercise of its sound discretion. The three-judge court must remain open to a showing by either party that the injunction should be altered to ensure the rights and interests of parties are given all due and necessary protection. The state may wish to move for modification of the three-judge court's order to extend the deadline for the required reduction to 5 years from the entry of the judgment of this court. The three-judge court may grant such a request provided the state satisfies necessary and appropriate preconditions designed to ensure that measures are taken to implement the plan without any untimely delay. If significant progress is made towards remedying the underlying constitutional violations, that progress may demonstrate that further population reductions are not necessary, or at least not as urgent as previously believed. Were the state to make this showing, the three-judge court, in the exercise of its discretion, could consider whether it is appropriate to extend or modify the timeline. These observations reflect the fact that the three-judge court's order, like all continuing equitable decrees, must remain open to appropriate modification. They are not intended to cast doubt on the validity of the basic premise of the existing order. The mental and medical health care provided by California's prisons falls below the standard of decency that adheres in the Eighth Amendment. This extensive and ongoing constitutional violation requires a remedy, and a remedy will not be achieved without a reduction in overcrowding. The relief ordered by the three-judge court is required by the Constitution and was authorized by Congress and the PLRA. The state shall implement the order without further delay. The judgment of the three-judge court is affirmed. That was Kennedy, the Romantic Poet's decision. We have a dissenting opinion from Justice Scalia, with whom Justice Thomas joins in dissent. We'll get to that in 1 second. So it looks like Scalia wrote the dissent, so probably pretty interesting vocabulary and writing style-wise. Thomas joined it, so he didn't write it. So let's see what they have to say. All right. Scalia writing, Justice Thomas just joins dissent in the dissent. Today, the court affirms what is perhaps the most radical injunction issued by a court in our nation's history. There comes before us now and then a case where proper outcome is so clearly indicated by tradition and common sense that its decision ought to shape the law rather than vice versa. One would think that, before allowing the decree of a federal district court to release 46,000 convicted felons, this court would bend every effort to read the law in such a way as to avoid that outrageous result. The proceedings that led to this result are a judicial travesty. I dissent because the institutional reform the district court has undertaken violates the terms of the governing statute, ignores bedrock limitations on the powers of Article III judges, and takes federal courts wildly beyond their institutional capacity. Scalia is pissed. 1A. What has been alleged here is the running of a prison system with inadequate medical facilities that may result in a denial of needed medical treatment to a particular prisoner or prisoners, paraphrasing statutory focus on the rights of a particular plaintiff or plaintiffs, thereby violating, according to our cases, his or her Eighth Amendment right. But the mere existence of the inadequate system does not subject to cruel and unusual punishment the entire prison population in need of medical care, including those who actually receive it. The court acknowledges that plaintiffs, quote, do not base their case on deficiencies in care provided on any one occasion, quote. Rather, plaintiffs rely on system-wide deficiencies. But our judge-empowering, evolving standards of decency jurisprudence, and with which, by the way, I heartily disagree, does not prescribe, or at least has not until today prescribed, rules for the decent running of schools, prisons, or any other government institutions. It forbids the denial of medical care to those who need it. And the persons who have a constitutional claim for denial of medical care are those who are denied medical care, not all those who face a substantial risk, whatever that might be, of being one day denied medical care. It is inconceivable that anything more than a sound proportion of prisoners in the plaintiff's classes have personally received sufficiently atrocious treatment that their Eighth Amendment rights were violated. What procedural principle justifies certifying a class of plaintiffs so they may assert a claim of systematic unconstitutionality? I think of two possibilities, both of which are untenable. The first is that, although some or most plaintiffs in the class do not individually have viable Eighth Amendment claims, the class as a whole has collectively suffered Eighth Amendment violations. That theory is contrary to the bedrock rule that the sole purpose of a class-wide adjudication is to aggregate claims that are individually viable. The second possibility is that every member of the plaintiff class has actually suffered an Eighth Amendment violation merely by virtue of being a patient in a poorly run prison system, and that the purpose of this class is merely to aggregate all those individually viable claims. Under this theory, each and every prisoner who happens to be a patient of the system that has systematic weaknesses has suffered cruel and unusual punishment, even if that person cannot make an individualized showing of mistreatment. Such a theory of the Eighth Amendment is preposterous, and we have said as much in the past. Quoting from Lewis v. Casey, a 1996 Supreme Court case, quote, if a healthy inmate who had suffered no deprivation of needed medical treatment were able to claim a violation of his constitutional right to medical care simply on the ground that the prison medical facilities were inadequate, the essential distinction between judge and executive would have disappeared. It would become the function of the courts to assure adequate medical care in all prisons. B. Even if I accepted the implausible premise that the plaintiffs have established a system-wide violation of the Eighth Amendment, I would dissent from the court's endorsement of a decrowding order. That order is an example of what has become known as structural injunction. Structural injunctions are radically different from injunctions traditionally issued by the courts of equity. Structural injunctions depart from the historical practice of limiting mandatory injunctions to requiring a single simple act that requires no continuing supervision. They turn judges into long-term administrators of complex social institutions such as schools, prisons, and police departments. Indeed, they require judges to play the role essentially indistinguishable from the role of ordinarily played by executive officials. Today's decision not only affirms that structural injunction, but vastly expands its use by holding that an entire system is unconstitutional because it may produce some constitutional violations. This case illustrates one of the most pernicious aspects of structural injunctions, that they force judges to engage in a form of fact-finding as policymaking that is outside the traditional judicial role. The fact-finding judges traditionally engage in what they engage in involves the determination of a past or present facts based on a closed trial record. In a very limited category of cases, judges have also traditionally been called upon to make some predictive judgments, which custody will best serve the interests of a child, for example, or whatever a particular one-shot injunction will remedy the plaintiff's grievance. When a judge manages a structural injunction, however, he will inevitably be required to make very broad empirical predictions, necessarily based in large part upon policy views, the sort of predictions regularly made by legislators and executive officials, but inappropriate in the third branch of our government. This feature of structural injunctions is superbly illustrated by the district court's proceeding concerning the decrowding order's effect on public safety. Here, the district court made the factual finding that the state has available methods by which it could readily reduce the prison population to 137.5% of design capacity or less without any adverse impact on public safety or the operation of the criminal justice system. It found the evidence is clear that prison overcrowding would perpetuate a criminogenic prison system that itself threatens public safety. The district court cast these predictions, and the court today accepts them as factual findings, made in reliance on the procession of expert witnesses that testified at trial. But these findings have support in the record. It is difficult to reverse them under a plain error standard of review. And given the district court devoted nearly 10 days of trial and 70 pages of its opinion to the issue, it is difficult to dispute that the district court has discharged its statutory obligation to give substantial weight to any adverse impact on public safety. But the idea that the three district judges in this case relied solely on the credibility of the testifying expert witness is fanciful. Of course, they were relying largely on their own beliefs about penology and recidivism. And of course, different district judges or different policy views would have found that rehabilitation would not work and that releasing prisoners would increase the crime rate. I'm not saying the district judges rendered their factual findings in bad faith. I'm saying that it is impossible for judges to make factual findings without inserting their own policy judgment when the factual findings are policy judgments. The dressing up of policy judgments as factual findings is not an error peculiar to this case. It is an unavoidable concomitant of institutional reform litigation. When a district court issues an injunction, it must make a factual assessment of the anticipated consequences of that injunction. And when the injunction undertakes to restructure a societal institution, assessing the factual consequences of the injunction is unnecessarily the sort of predictive judgments that a system of governments allocates to other government officials. The district court also relied heavily on the views of the receiver and special master, and those reports played a starring role in the court's opinion today. The use of these reports is even less consistent with traditional judicial role than in the district court's reliance on the expert testimony at trial. Relying on the uncross-examined findings of an investigator sent into the field to prepare a factual report and give suggestions on how to improve prison systems bears no resemblance to any ordinary judicial decision-making. 3. In my view, a court may not order a prisoner's release unless it determines that the prisoner is suffering from a violation of his constitutional rights and that his release and no other relief possible would remedy the violation. Thus, if the court determines that a particular prisoner is being denied constitutionally required medical treatment and the release of that prisoner and no other remedy would enable him to obtain medical treatment, then the court can order his release. But a court may not order the release of prisoners who have suffered no violations of their constitutional rights merely to make it less likely that they will happen to them in the future. My approach may invite the objections that the PLRA appears to contemplate. structural injunctions in general, and mass prisoner release orders in particular. Moses. The statute requires courts to, quote, give substantial weight to any adverse impact on public safety or the operation of a criminal justice system caused by the relief, and authority authorizes them to appoint special masters, provisions that seem to presuppose the possibility of a structural remedy. It also sets forth criteria under which courts may issue orders that have, quote, the purpose of affecting or reducing or limiting the prison population, end quote. I do not believe that objection carries a day. In addition to imposing numerous limitations on the ability of district courts to order injunctive relief with respect to prison conditions, the PLRA states that, quote, nothing in this section shall be construed to repeal or detract from the otherwise applicable limitations on the remedial powers of courts, end quote. The PLRA is therefore best understood as an attempt to constrain the discretion of courts issuing structural injunctions, not as a mandate for using them. Oh, that's the end of Scalia's. So that was Scalia's dissent, which Thomas joined on to. And we now have Justice Alito, with whom Chief Justice Robert joins in dissenting. So we got the majority, which Kennedy wrote. We have the Scalia dissent, which Thomas joined on to. Now we have the Alito dissent that Justice Roberts joined on to. But Roberts and Alito did not join Scalia and Thomas's dissent. So they have their own reasons separate and apart from Thomas's, Scalia's reasons. All right, Alito's opinion. The decree in this case is a perfect example of what Prison Litigation Reform Act of 1995 was enacted to prevent from happening. The Eighth Amendment prohibits officials from depriving inmates of the minimal civilized measure of life's necessities, from a Supreme Court case called Rhodes v. Chapman, an 1981 case. Federal courts have the responsibility to ensure that this constitutional standard is met, but undesirable prison conditions that do not violate the Constitution are beyond the reach of the federal courts. 1. Both the PLRA and the general principles concerning injunctive relief dictate that a prisoner release order cannot properly be issued unless the relief necessary to remedy an ongoing violation. The scope of permissible relief depends upon the scope of any continuing violations, and therefore it was essential for the three-judge court to make a reliable determination of the extent of any violations as of the time of the release order was issued. Particularly in light of the radical nature of its chosen remedy, nothing less than an up-to-date assessment was tolerable. The three-judge court, however, relied heavily on outdated information and findings and refused to permit California to introduce new updated evidence. By the date of the trial before the three-judge court, the death rate had been trending downwards for 10 quarters, and the number of prisoners likely to have preventable deaths fell from 18 in 2006 to 3 in 2007, an 83% decline. Between 2001 and 2007, the California prison system had the 13th lowest average mortality rate of all 50 state systems. 2. The PLRA's remedial limitations largely reflect the general standards of injunctive relief aimed at remedying constitutional violations by state and local governments. Quote, the power of the federal courts to restructure the operation of local and state governmental entities is not plenary. Once a constitutional violation is found, a federal court is required to tailor the scope of the remedy to fit the nature and extent of the constitutional violation, end quote, quoting from the case of Dayton. Here, the majority and the court below maintain that no remedy short of a massive release of prisoners from the general population can remedy the state's failure to provide constitutionally adequate health care. This argument is implausible on its face and is not supported by the requisite clear and convincing evidence. I do not dispute that general overcrowding contributes to many of the California system's healthcare problems, but it by no means follows that reducing overcrowding is the only or best or even a particularly good way to alleviate those problems. The release order is not limited to prisoners needing substantial medical care, but instead calls for reduction in the system's overall population. Although some class members will presumably be among those who are discharged, the decrease in the number of prisoners needing mental health treatment or other forms of extensive medical care will be much smaller than the total number of prisoners released, and thus the release will produce at best only a modest improvement in the burden on the medical care system. The state proposed several remedies other than a massive release of prisoners, but the three-judge court, seemingly intent on attacking the broader problem of general overcrowding, rejected all of the state's proposals, and in doing so, the court made three critical errors. First, The court did not assess those proposals and other remedies in light of the conditions proved to exist at the time the release order was framed. Second, the court failed to distinguish between conditions that fell below the level that may be desirable as a matter of public policy and conditions that do not meet the maximum level mandated by the Constitution, or minimum level mandated by the Constitution. Third, the court rejected alternatives that would not have provided immediate relief, but nothing in the PLRA suggests that public safety may be sacrificed in order to implement an immediate remedy rather than a less dangerous one that requires a little more extended time, but still a reasonable period of time. If the three-judge court had not made these errors, it is entirely possible that an adequate but less drastic remedial plan could have been crafted. Without up-to-date information, it is not possible to specify what such a plan might provide, and in any event, that is not a task that should be undertaken in the first instance by the Supreme Court of the United States, but possible components of such a plan are not hard to identify. Sanitary procedures could be improved, sufficient supplies of medicine and medical equipment could be purchased, an adequate system of records management could be implemented, and the number of medical and other staff positions could be increased. Similarly, it is hard to believe that staffing vacancies cannot be reduced or eliminated, and that the qualifications of medical personnel cannot be improved by any means short of a prisoner release. Without specific findings backed by hard evidence, this court should not accept the counterintuitive proposition that these problems cannot be ameliorated by increasing salaries, improving working conditions, and providing better training and monitoring of performance. While the cost of a large-scale construction program may well exceed California's current financial capabilities, a more targeted program involving the repair and perhaps the expansion of current medical facilities as opposed to general prison facilities might be manageable. After all, any remedy in this case, including new programs associated with the prisoner release order and other proposed relief now before the three-judge court, will necessarily involve significant state expenditures. Measures such as these might be combined with a targeted reduction in critical components of the state's prison population. A certain number of prisoners in the classes who, on behalf of the two cases were brought, might be transferred to some out-of-state facilities. Finally, as a last resort, a much smaller release of prisoners in the two plaintiff classes could be considered. 3. Before ordering any prisoner release, the PLRA commands that a court, quote, give substantial weight to any adverse impact on the safety of the public or the operation of the criminal justice system caused by the release. Section USC 3626A1A. The provision unmistakably reflects Congress's view that prisoner release orders are inherently risky. The three-judge court in this case concluded that loosing 46,000 criminals would not produce a tally like that in Philadelphia, where prosecutors claimed, without offering documentation, that prisoners released by court order committed 79 murders and would actually improve public safety. This is a fundamental and dangerous error. When a trial court selects between the competing views of experts on broad empirical questions, such as the efficacy of preventing crime through the incapacitation of convicted criminals, the trial court's choice is very different from a classic finding of fact and is not entitled to the stated degree of deference on appeal. I feel that today's decision, like prior prisoner release orders, will lead to a grim roster of victims. I hope that I am wrong. In a few years, we shall see. A lot of the opinions, especially that second dissenting opinion, is omitted in my stupid casebook because I start abridging shit nowadays, which sucks. But that's the end of the case in the casebook. So that would have meant this was an 11 case. So the people, so it had been 5 votes for the case and 4 votes against it. Dissenting would have been Alito, Scalia, Thomas, Roberts, and that's it. The justices voting for it would have been Sotomayor, Ginsburg, Kennedy, Stevens, and Brennan would have been the 5 who voted for it. So 5-4 split, but there you go, guys. There you go, kids. All right, that's our modern American remedies reading for the evening. Tip your bartenders, tip your cocktail waitresses, tip your hosts and stewardesses, and your airplane pilots. If you're on the plane right now, good luck, safe landing. Love y'all. God bless you, and good night. We'll see you tomorrow.